This episode is brought to you by Roundtable Group, the experts on experts. We've been connecting attorneys with experts for over 30 years. Find out more at roundtablegroup.com.
Welcome to Engaging Experts. I'm your host, Noah Ballmer, and today I'm excited to welcome Frederick Fisher to the show. Now, Mr. Fisher is the founder of Fisher Consulting Group, a loss control and prevention consultancy, as well as an expert in risk management and compliance. He's a sought-after speaker and presenter and holds a JD from Lincoln University Law School. Mr. Fisher, thank you so much for joining me here today.
Oh, it's my pleasure. I hope I don't scare everybody away.
Not at all. Let's jump into it. So you've spent over 50 years in the liability services sector. How did you first become involved in expert witnessing?
I guess I had already been in an area of insurance now called specialty lines. And I had, at the time, I was the owner of an independent claim adjusting firm and also we acted as a third-party claim administrator, where we actually were acting as if we were the claim department of an insurance company.
Sure.
And specialty lines insurance really is a phrase that deals with what's called professional liability insurance. So the kind of claims we were handling were claims against lawyers and accountants and architects and engineers and a lot of insurance agents and brokers and a lot of real estate agents and brokers. We also handled some med mal, although I tended to stay away from that. I got way too real. But we handled a lot of dental malpractice cases and what have you. And over time, you start seeing, number one, patterns. And you think to yourself, wow, this claim was preventable. All they had to do was this, or all they had to do was that. And sometimes it was really just documenting something, which you didn't do. Oh, and so the phrase came along that if you didn't write it down and document it, it didn't happen. And so I developed this expertise, and I started publishing articles on how to prevent claims. And I think in 1981 even wrote a book for real estate agents and brokers, which to my knowledge may still be the only book written on how to do things so you don't get sued.
Wow.
It was called Broker Beware: Selling Real Estate Within the Law. And I was getting high profiled in the sense that I was writing a lot of articles that were being published in the national trades. And somebody I knew called me up one day, and he had this real estate malpractice case. And he said, you're the perfect guy that could testify as to this. Would you be willing to consider being hired as an expert? And that's how that started in 1988. And it was kind of fun. And once I learned the way to really handle things, which took a couple of cases, 2 or 3 cases before I kind of realized, hey, you're making some mistakes here. Let's rethink this, so to speak. I just started handling it, and I did, doing some. And I knew enough attorneys certainly that were interested. I had to be careful with it because I had a business to run, and so I'd only take a couple of cases a year, maybe, or 2 or 3, and that would be about it. And one thing led to another. But I always figured, someday I might actually retire. But, you still have to have a reason to get up in the morning. So I figured, who knows? I may end up, wanting to do more expert witness work than I'm currently doing. And so that's kind of how it all fell into place. And then, I am a deep diver. I only take cases I agree with. I'm not dependent on the money. Knock on wood, so I can afford to turn cases down, and I do repeatedly. Or if the attorney is really up against the wall, I said, look, the best I can do is this. I'm not going to go over here. I'm only going to deal with this slice, so to speak.
Right.
That works for you, fine, but I'm limiting it, and I will make that disclosure in deposition, for instance.
There's a couple things to unpack there. So you were talking about when you were very first getting started, it helped to get a couple cases under your belt. What were some of those earlier mistakes or things that you learned that made you a better expert from when you very first were getting started?
Not being an advocate, number one. Suddenly realizing it's not my job to win the case. It's not my job to try and win the case in deposition. It's my job to answer the questions truthfully.
Right.
That's all. Answer the questions truthfully. And the big difference between telling the whole truth and answering the questions truthfully, especially when you're dealing with a question that calls for a yes or no answer. Why volunteer anything if you don't have to? But on the same token, you have to also, now there's a lot more articles and stuff you can find on the subject, but back then there was no internet. So where are you going to get this information from? And you just learn the hard way what kind of tricky questions lawyers can come up with. Long ago, I learned that as soon as they say, well, Mr. Fisher, when you testified earlier, I know right then and there, number one, they're going to misstate the question. Number two, they're probably going to misstate the answer. And I'll make them go back. I'll say, I said, I think you've misstated it, and I'd like the court reporter to go back. And invariably, they'll withdraw the question. And or questions that are so broad that you really can't answer yes or no. You can't, because then they'll come up with the exceptions later at trial and trying to cross-examine. Oh, Mr. Fisher, did you say this? Did you say that? And so you learn, how to deal with those, or never say anything absolute. Well, do you always do that, Mr. Fisher? Yes. And then all of a sudden you just open yourself up to the exceptions, right?
Sure.
And so you learn the proper way of dealing, again, with those kinds of questions and how to answer them and still meet the obligation you have to tell the whole truth. And so I love that, in the sense that, it didn't take long to figure out, here are the tricky questions and here's how you deal with them.
So you get an initial phone call and you know that you only like to take cases, or you only will take cases that you quote unquote agree with. How do you find that out? How do you figure that out during the initial phone call?
I'm a trained investigator. I know how to ask questions. Well, it depends on what the nature of the case is, for instance. And then I'll start asking pointed questions based on, my knowledge. And if I don't have the knowledge, why am I even considering it, right?
Sure.
So, I do a lot of insurance agent and broker professional liability cases. I do a fair amount of real estate E&O cases because I understand that industry. I'll even handle a variety of other oddball stuff, but only if I feel I have the expertise.
Mm-hmm.
I'll even handle some attorney malpractice cases if it's an obvious situation. For instance, he blew the statute of limitations. Well, that's a no-brainer. Now, the question is whether any damages took place. Just because he made a mistake doesn't mean there was any resultant damages. But and so I've handled some attorney malpractice cases. Would I be knowledgeable, or do I think I'd be competent to be an expert where they're doing merger and acquisition kind of counseling? Probably not. Unless it was an issue, again, that I'm familiar with, like very narrow. But that would, so I know where my limits are. And like I said, I don't need to try and charge somebody money and then screw it all up, right? I don't need to do that. But it really is a question of probing. And sometimes I'll come up with ideas the attorneys hadn't thought of, and all of a sudden it's like, oh my God, that's a game changer. But that's why they're talking to me, hopefully, is that I know the industry better than they do. Sure. And I have, often come up with stuff that they hadn't considered. Like, I was like, wow. And the whole posture of the case changes. And then there's the obvious. Every time I get a phone call and say it has to do with an insurance agent or a broker, for instance, as soon as they tell me what it's about, I'm already on the internet looking up their license with the Department of Insurance. And boy, the things you find out there.
You've been at this long enough to have seen these changes, to have seen not just your field, but expert witnessing in general for your field change throughout the past. You've been doing this. You said your first engagement was sometime in the 80s. So
yep. How
has technology changed expert witnessing for you?
Well, number one, from the standpoint of research, having the internet available has made things enormously easy. And there are so many organizations now that are publishing articles, attorneys that like publishing, a review of a particular appellate decision. And, certainly some of the law firms I already know, and they have their own websites and you can subscribe to their newsletters. But there are so many other law firms out there you've never heard of, or I've never heard of. And those are picked up by aggregating organizations such as JD Supra or Lexology.
Right.
and another one is the Mondac. And I subscribe to all three of them. And so every day I get a feed and of maybe on a list of 25 or 30 different appellate decisions, 3 might spark my interest because they're in the areas that I'm interested in, or sometimes none. But boy, the stuff I pick up on so fast. And you didn't have that ability back then. And as a backstory to that, one of the things that my claim adjusting firm did was we subscribed to, back before the internet, of course, we subscribed to what was called the advance sheets. And what that was like a paperback publication that came out about a month after the month closes. And in it was all the latest and greatest state appellate court decisions that were ordered published, as well as Supreme Court decisions that were ordered published. And so you could scan through it quickly and see which cases were of interest by topic. And that helped us in 2 areas. If it was a coverage decision, then that would help us in the way we analyzed a particular policy that, was the one in issue in that case, for instance. And if it was a liability issue involving, again, the types of claims we were handling, then we knew how liability had been increased or decreased or what have you. And so between the two, getting information on cases involving coverage or liability also gave us ability to enhance the questions that we would be asking during our investigation. And that was a valuable lesson. And in addition, I think there was a law firm that used to publish a monthly column in Insurance Week magazine, but they published a monthly column on either liability that would be of interest to insurance brokers or coverage. And so that was another reinforcement of that. And so with the internet, when I was came along, I think we were still doing claims, and so that helped us a lot. And then as I made the transition into becoming, an insurance producer on a wholesale and MGA level, again, coverage decisions were certainly ones we were interested in, but so as well as liability. How is the liability changing now? And is there insurance policies that will even cover that? So it gave us that leg up. The old saying, knowledge is power. Well, there's a good example of it. And so even now, I'm religious about looking at these feeds. And, there's another law firm, a very prominent law firm, used to put out a monthly magazine on an e-magazine, not hard copy, but sure. Monthly magazine on the latest and greatest cases and on specialty lines. The partner who was in charge of it was somebody I personally knew. And he was extolling the use of absolute exclusions. And I've been on a warpath about those since 2009. I've probably written 5 articles on the dangers of absolute exclusions, including a big one that the International Risk Management Institute published in, I guess, 2020, 2021, something like that. And we looked at, it was a review of 30 decisions involving the enforcement of absolute exclusions and how broadly they're being interpreted and how bad these cases are getting. And, whatever happened to the reasonable expectation of the insured? Out the window, the language is clear and unambiguous. What happened to the concept of contracts of adhesion and unequal bargaining position? Out the window, the language is clear and unambiguous. I mean, we've migrated from what insurance is all about and how things should be interpreted to this fanatical concept that if the contract is clear and unambiguous, it will be enforced. What happened to that? Or the old adage that insuring agreements are going to be broadly interpreted and exclusions narrowly construed. Well, again, you got a Ninth Circuit judge saying, and I quote, "We are about to enforce a staggeringly broad exclusion." Staggeringly broad. So all these old insurance maxims are dying. I actually wrote an article on that called "Litigation is Good," right? And I talk about how all these maxims are out the window. And it was published by the Professional Liability Defense Federation. This is an organization of defense lawyers. And I'm a member of the organization. And at one time I was originally vice chair, then co-chair of the Insurance Agent and Broker Committee. And just remember, when these cases come down, and the brokers are going to get sued. They're going to get sued for malpractice. Whether they can be sustainable or not is another question. But still,
sure.
they're going to get sued. So they're being thrown under the bus daily. And I have to hand it to the PLDF for publishing that article because it was against the grain.
When you write something that's against the grain, do you ever worry about, do you ever end up on the opposite side of a matter with somebody who wrote the opposing article and have to confront them on the details of these sorts of things?
No, I haven't had that happen, but I will say that again, to the credit of the PLDF, I was writing an article because one of the contentious things, especially on the insurance agent and broker committee, was, do wholesalers have a duty to anybody? Well, of course they do, but they like to have you believe we're just a conduit,
right?
Which is rubbish, especially when you look at some of the advertising wholesalers do on the internet.
Right?
What are you talking about? They don't say we're being a conduit here, but I've had a running disagreement with a particular person of that association on this topic. So they asked me to write an article. I said, well, I'm going to talk about the liability of wholesalers. And then I invited the other fellow to do a counterpoint article. It had never been done before, for the PLDF journal. And the editor was all for it. She said, that's a great idea.
Sure. That's exciting to read.
Oh, yeah. And so he did. And later on, he complimented me. He said, I can't believe you did that. And I said, why not? Just because we have a difference of opinion, so what? Let people decide for themselves who they think has a better purpose. But, you have to understand, we have forgotten what insurance is all about. Insurance is supposed to put you back in the position you're in before the loss.
Right. Make you whole.
And it's supposed to be a pool of people in the same situation, and they pay money into the pool. And hopefully there's enough money there to pay whatever claims happen, and everybody's happy. And I didn't have any claims, but I'm helping you get back on your feet. But what if I have a claim? Then you guys are paying for me to get on my feet. So it kind of works out. Hopefully I won't have to, but at least I know it's there.
How do you get ready for something that's going to be a huge action? There's going to be contentious cross-examinations and probably tense depositions, all of that. What do you do to get centered and ready and prepared to perform in court?
It wasn't that difficult. I knew what the issues were. It was quite simple. Obviously, the court's never going to let me interpret coverage.
Right.
But all I had to do was, this is what was done, and it was solid, in my opinion. I was very well prepared. Facts spoke for themselves. I'd done my homework, and no matter what they threw at me, and I showed it to it. It happened at the trial. This is historical. One of the things they wanted to try, one of their tactics was to try and put together the position that the quote definition of claim is ambiguous, right? And I had written an article. I've written many articles on the dangers of claims made. I've written so many articles on claims made forms, and one of them probably showed up maybe 10 or 15, different definitions. So this law firm wants to try and claim that the definition of claim is ambiguous, right? So they pulled the article, but they just pulled out the definitions. So he puts a definition up there, and he says, "This look familiar to you?" I says, "Yeah." "Where's the rest of the article, counselor?" By the third time he put up a different definition, I'm saying, "What is it about this article you don't want the jury to see? Why don't you put the entire article up?"
So you as an expert witness argued a little bit with the attorney, rather than letting
the judge was letting me get away with it too.
Wow, I was going to say that's not something that experts are coached to do very often. Tell me,
I wasn't coached, but the judge was sitting there and not saying anything. So okay, I'm going to run with it. Well, but my answer ultimately was the same, counselor. There's no question that different definitions, can create some issues. But at the end of the day, this case has to do with making a disclosure of either a claim you know about or making a disclosure of a potential claim. And the solution doesn't matter what the definition is. The solution is report all claims and all potential claims immediately. And when you're applying for coverage, disclose them as well. Right. That's the solution. It doesn't matter what the definition is. So he keeps another definition comes up on screen, right? Same answer. Finally, we're getting up to number 9 or number 10, and I'm counting them. I said, are you going to go for a dozen? Meanwhile, now the jury's starting to laugh. And are you going to go for a dozen? I said, look, you're just proving my point. As complicated as all this can be, the solution isn't report all claims and disclose all claims and potential claims, report them as well, and problem solved.
Right.
So then he gets to 12 and I say, are you going to go for a Dacre's dozen now? Now the jury is laughing their heads off, right? And I actually, but when we got up to number 14, I toyed with the idea of turning to the jury and saying, you want to help me with the answer as a chorus? I really thought about that and decided, let's not push the judge. And finally he intervened and says, all right, counselor, I've heard enough too. This is going nowhere. Move on.
I've heard from other expert witnesses that once you get a chuckle out of the jury, it's essentially over. You've won them over.
Well, juries tend to like me for a lot of reasons.
Tell me about it.
Well, number one, I don't come off like an expert. They don't know, well, I'm the expert here, ladies and gentlemen. I know you're going to listen to everything I have to say. But no. Even during the initial voir dire, they talk about speeches and seminars and articles and now books. And my attitude is, look, it may sound impressive, but unless you're in the industry, you wouldn't necessarily know that. And number two, it's only of interest to people having trouble sleeping. My books and articles are guaranteed to cure insomnia. Now I'm making fun of myself.
Right.
But the other thing that I've been told is that I have a unique ability of taking complicated concepts and explaining them in a way that people can understand without, most importantly, without appearing condescending.
Mm-hmm.
And I can do it by example.
Okay.
Here's what this really means, and you give it an example they can relate to, and they like that. And I'm not talking down to them, and actually being apologetic, and
Sure.
and so I'm that way. But at the end of the day, when I know I'm right, I know I'm right, and I won't back down. I was in a case some years ago. There was 219 million on the table. Most of it had to do with change orders on a highway construction project. This poor jury had to listen to 3 months worth of change orders. Oh my God. I would have been brain dead after that. Right? What could be more boring than that, than maybe taxes?
Right.
But my portion of the case was very narrow and limited, but it was contentious. And I stuck to my guns. I knew I was right. And the attorney at one point, asked me this question. I said, counselor, I don't know how many times I have to say this. I never would have made that recommendation to my customer. I just wouldn't. And it would never happen on my watch. Not on my watch. I think I said that 4 or 5 times, they pushed that issue. And
sure.
This was early in the case. This was in month number 1. So 2 months will go by. I finally get a phone call from the attorney. Well, we got a verdict. You're not going to believe it. We won. So I said, God, what did the jury have to say? Well, you're not going to believe this, but one of the things that really stuck in their minds was when you stood up to that attorney and said, not on my watch. They remembered that.
Do you typically follow cases after your part is done to see who won, who lost, how your performance was, what the jury said, those sorts of things?
Yes, I do. I want to know what happened, and I want to know whether I was of assistance. For no other reason are they going to use me again? And I do. And most of the time, the attorneys will call me after the verdict comes in, and of course, invariably, as an expert, I'm usually, especially if I'm on the defense side, I'm the last guy to testify.
Mm-hmm.
And so, usually, but I do want to know what happened. And did I do anything wrong or screw anything up? And invariably, I'm always told, no, they loved you. You did a great job. And then, of course, the ultimate question: would you use me again? Yes.
Is that how you get? Is repeat business a lot of your work?
I wouldn't say a lot, but I do have repeat business, especially on the defense side. Although I'm getting some repeat business on the plaintiff side now too, just because they know I'm a game changer, and I come up with stuff that nobody had thought of.
As a JD, is it ever difficult to turn that off and not interpret the law?
No, it's not hard for me at all. I know where to draw the line. I said, I'm not here to interpret the law. All I know is this is what I'm supposed to do, and this is the regs that tell me what I have to do and what not to do, and that's pretty clear. And then I stop. And the same thing with questions of fact. I won't decide questions of fact. I will do an either or analysis. And boy, I'll tell you, 100% of the time, when an opposing expert is an attorney, I love it. Especially when I'm dealing with a state or a federal court where I have to issue a rebuttal. They always cross the line. And I'll open my rebuttal with, a paragraph that basically says, I didn't know if he was writing a brief or a thesis for a master's degree in law or what. But one thing I do know, he was citing law, which he's not supposed to do. And he was advocating the facts, what he's not supposed to do. And I said, that's completely inappropriate as a role of an expert. And 100% of the time, the magistrates or the judges have agreed and gutted 80 to 90% of their report for that very reason. I don't need you citing cases, counselor. I don't need you advocating a position like it's, closing argument, which is what they do. And I won't decide questions of fact. And this came up in a case in Nevada, which follows the federal rules. And one of the key points of the case is no evidence of this, no evidence of that. Mm-hmm. And then this witness came up and provided the declaration, provided the report, and he was providing a precipient witness kind of thing. And he brought up something that caused me to have to, in my rebuttal, I had to say, look, now we have a fact here that's being alleged. And I'm not going to decide a question of fact. So here's my review. It either is or it isn't. However, when this event took place was after the loss. So in reality, it's irrelevant anyways.
Do you find that attorneys appreciate you kind of helping with trial strategy to some extent?
Well, I don't do trial strategy or case or what I call case plan. I might ask them about it. And sure. When they tell me, well, we'd rather have you do it this way or say it that way, or we want to de-emphasize this and emphasize that. My attitude is if it does not affect my opinions, then I'm happy to do that because I don't want to interfere with their case plan. And even if I think I'm right, you really need to emphasize this. If they don't want to do it, I'm not going to argue with them because it still doesn't affect my opinion. But if they're smart, they'll listen to what I have to say. And and more often than not, they do. But, like I said, for instance, I've had some attorneys tell me, we want you to write your report and you're free to tear this guy apart. Or, no, we want you to take the high road. And that's fine with me. I don't care. But even when I tear them apart, I don't do it with strong adjectives. I want to stay away from that. I don't want to tick off the judge or anything. But on the same token, it's just like, okay, here's where he's wrong. I don't need to editorialize it beyond that.
Even though you might want to.
Oh, yeah. There's certainly been times I wanted to do that, believe me.
You're a published author. You're a sought-after speaker and a presenter, and you've been doing this for a long time. You've written a lot of reports. Do you ever worry about keeping track in your head of every little thing that you've ever said on a subject such that, it might come up in a deposition, it might come up during cross and getting impeached on something that you said a very long time ago? How do you keep track of all of that?
It's easy. I'm 100% consistent.
You never change your mind?
I never change my mind with one exception.
What's that?
One exception. Jurisdictional differences. And I make that clear. And that's why I love it when somebody wants to try and cross-examine me with one of my articles. Well, good luck with that. You're going to run into a buzzsaw. And that just happened recently in the matter. The guy says, "Does this sound familiar to you, Mr. Fisher?" And I said, "Yes, it does." And I said, "The only thing missing from what you've just quoted me is where I was talking about how I agree with the standard of care." And then and as a personal opinion, then I said, I don't agree with it. But that was a
Mhm.
personal opinion. Let's go to that portion of the article that you didn't bring up on screen. Because if you don't want to do it now, we'll do it in trial.
Do you find that people take you out of context in that manner a lot? Is that a
They
common
try.
strategy?
No, they try.
So that's something
But
that expert witnesses should be aware of.
well, yeah, you have to be careful if you're going to write articles, if you're going to give speeches, you have to be careful what you say because it could come back to haunt you. There's no question about it. So if I'm doing a presentation, if I'm writing an article, depending on the context, I'll make it clear this is a jurisdictional question and that other states don't follow it, and or what have you. But and I get that, but I'm clear about that when what I'm doing because I know that might be used, and I don't worry about it because when that happens, I know I can talk around it very easily, and it's accurate. Why don't you put it on screen? Is there something you don't want the jury to see?
This is such a dynamic field with all of these laws and rules and regulations changing. And of course, the jurisprudence then changes everything on top of that. How do you maintain, how do you stay current in your field in general?
Well,
Are you constantly just, reading all of the case law? You obviously are a professional speaker. Do you also attend seminars? What are
oh
the
yeah,
sorts of things that you do to stay abreast of everything?
I do both. When I can, I'll sign up for a seminar or webinar. In addition, I get all these feeds, and there are articles written by law firms, and sometimes they include the actual case, and sometimes they don't. Um, but if I really want to read the case, it's not hard to find. But I look at those articles, and that tells me what I need to know, and then I store them. I must have gigabytes of articles broken down by category, with or without the actual appellate decision, and that's how I stay abreast. And then there's a lot of articles that other people are writing like I do, and I read their stuff too. And that's how I stay on top of things. One
Yeah.
thing I really, 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 really like to see from lawyers: get your goddamn experts lined up early in the case. I am so sick and tired of saying, "Oh, we have an urgent need and the report's due by the end of the month." Well, good
Yep.
luck with that. You really think I'm sitting around here with nothing to do?
I have a lot of experts who say that they charge 1.5 or double for those rush jobs.
But I'll give you a good example of why that's just physically unsafe. First of all, the downside to it, number one, is that I would say 80% of the time, by the time I get retained, discovery is already closed. And I'll be asking questions about stuff, and they'll say, gee, we don't have that, or we didn't get that, or we don't know. I say, well, discovery closed? Yes. Well, we're not going to find out now. That's number one. And number two, I may come up with stuff that, oh, wow, changes the game.
And there's no time to change
Yeah.
the strategy.
Sure. Yeah. It just can't be done. Or you got 42,000 pages of documents to read through in 2 weeks to be able to do a report, that sort of thing. And so
Right.
I'll give you a good example, though, of how this could really have a huge fiscal impact. I was hired very early in a case with an insurance broker malpractice case involving one of the largest insurance brokerages in the country, certainly in the top 10. And they just dropped the ball. I couldn't believe it when I was told what the case was about. I mean, literally, the executive vice president walks into the office to talk to the president of this big construction company over their proposed construction of this office building going up high rise in downtown Los Angeles. And of course, what immediately comes to mind is environmental liability, right? And there's two kinds. There's creating pollution during the course of construction. And then there's disturbing unknown pollution that may already be there during the same thing. So you need both. And there's plenty of insurance companies that have the capacity to write that coverage, and I know who they are. But that's not what happened. They got the one that covered only any pollution you create. And so they're excavating at downtown LA, and of course, there's going to be PCBs down there. You just know it, right? And that's exactly what they did.
Of course.
So they got denied coverage. So the guy calls me up, and like I said, I can't remember if the lawsuit had already been filed yet or not. But if it had, it was, probably it hadn't even gotten the answer yet. So we're really early in the case. So I'm asking all these questions, and he's giving me what little he knows. And I said, well, here's what we need to find out. But I can guarantee you Here's the answers. Number one, what insurance companies did they go to? Because here are the companies I know would have done automatically both. And if they didn't go to these insurance companies, the only reason I can think of is they can't get to them on their own. They can't deal direct for some reason. They got to go through a wholesaler, and they didn't want to share the commission. This guy's the executive vice president, right? I said, so you're telling me that the executive vice president of a major corporation is going to walk in the door to handle my account? Boy, am I impressed. Oh, thank you. Yeah, all right. But in reality, that's not what this guy is. This guy is not a corporate officer, although he has this big fancy title. So these are all questions to find out in discovery, right? And then we got to the thing about the insurance companies, of course. Who did they market to? And then were they dealing direct? And on and on, and the same with the title and this and that. I mean, just all these things. And during the course of maybe 2 years, or a year and a half, I'd get a phone call now and then. And he'd let me know the latest information he's gotten and how it fits exactly as I told him. Then it turned out this guy, I was right about his title. And then it turned out he wasn't even the expert on environmental. And I said, really? Who is? And he said, some person in because that was another question I suggested, find out who the expert is on environmental. And well, it turns out it's a guy in Chicago. But internally, they don't allow the sharing of commissions. This guy was the producer. He was the one that brought in the account. He gets all the commission. And so you think the guy in Chicago is going to help him at all? Not a chance. So when I heard that, now we're late in the case, we're getting later in the case, we're getting close to discovery, maybe getting closed, right? And of course, if the discovery had already been closed and he didn't have any of these answers, we'd be DED. But okay, so he calls me up and he tells me the latest and greatest about who the real expert was and why he wasn't utilized. And I started chuckling. I said, do you realize what's going on here? Because in my mind, they're willing to screw their policyholder to maximize their own revenue internally, and they don't care. I think you've got grounds to seek leave to amend your complaint to request punitive damages. And I told him why. And he said, okay, God, this is great. Thank you. So maybe a month or two goes by, calls me up and says, Fred, what are you doing for lunch today? I said, well, I maybe having it with you. What happened? Since we settled the case. Really? I said, and then he says, well, I can't tell you what it was, but my client's very happy. And I said, wow, that's fantastic. And I said, well, let me see how much time I have on this file. And it turned out I had $3,200 worth of time on it, just all phone calls. I hadn't reviewed anything. And I said, if we have lunch, I'll bring you your refund because, I had an evergreen retainer of $3,500 and I only could use 3,200 of it. So I brought him a check for $300. And I'm thinking, and then at lunch, I said, I got to compliment you, counselor. If I had to read 16 depositions and all the other discovery material, my bill before trial probably would have been about $35,000. And here I am giving you a $300 refund.
When cases go to settlement, does it have enough of a negative financial impact that you're like, I wish so many cases didn't settle? Or is it something that's just, the way that it goes these days?
If my deposition's been taken, I don't get upset.
Okay.
That means I had to put in a lot of time reviewing stuff and being prepared for my deposition. If it has before my deposition is taken, I remind the counsel, I said, don't you realize that this year is be kind to your expert year? You're not supposed to be settling. You're not supposed to be settling cases until I've, made a little money on this. But in reality, I'd rather see the case settle. I always say, congratulations, the best files. And if I gave them good advice and gave them a lot of good information that they could use, which I do. Yeah, it can be a game changer. And so even though my deposition hasn't been taken yet, I still do a fair amount of research on it. And a good example of that is another case that settled, but it was a situation that was ridiculous. They were acting like, oh yeah, this insurance was readily available, blah, 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 blah. So I went onto the California surf system and downloaded a whole bunch. And he actually, the opposing expert actually did a declaration, or maybe it was also in his deposition. And he listed out all the different companies that wrote this class of insurance, but he didn't look at the policies. He just rattled them off. Well, I downloaded them. What he's saying isn't true. Every single one of them he got shot down on. So, that one settled fine, but I got my research time into it. But to me, I don't need the money. I need a reason to get up in the morning.
Before we wrap up, do you have any last advice for expert witnesses or attorneys working with expert witnesses?
Well, sure. For expert witnesses, don't take cases you don't agree with. Don't take cases where you're on the edge of, am I even capable of handling it? And then you can never go wrong. As far as attorneys, for gosh sakes, be in contact with your experts, keep them up to date, and most importantly, get them on board early. It could save a lot of money. But waiting till the last minute means discovery's closed. And if you didn't get something during discovery because you didn't even know it could matter, you're toast. Get off. It ain't that expensive to hire an expert and just have a few phone calls up until it gets heated, so to speak.
Sure.
It really doesn't. And a good example of that is $3,200 versus $35,000.
Sage advice. Mr. Fisher, thank you so much for joining me here today. And thank you, as always, to our listeners for joining me for another edition of Engaging Experts. Cheers.
Thank you for listening to our podcast, Engaging Experts. Our show notes are available on our website, roundtablegroup.com.